Good evening, professionals. In our 10th Corporate Law webinar series, we've been discussing about one of the important legislation, the intellectual property rights, wherein we have started with the patent session. Today, we are in chapter 12 in continuation of our series and 10th session, where we are going to talk about simple provisions yet significant, surrender and revocation of patents. While Section 63 draws reference to surrender of patents, Section 64 draws reference to revocation of patents. Also, there are additional provisions in case of atomic energy under 65 and also under 66, where there is a reference for revocation in public interest. With this brief introduction, let's get into today's presentation, friends. My sincere thanks to Aishwarya and Hari Santoshi for this detailed presentation. They've also covered few interesting case laws more relevant to this subject. Some of the key legends used in today's presentation were IPAB. We will have a reference in the case law. Surrender of patents. Surrender of patents, it could be a voluntary surrender by the patentee himself. He may do it at any time, and the prescribed form is Form 14. And on such receipt, the action to be taken by the controller is he shall publish the notice of such offer relating to the surrender as provided under Section 63, and other than the person who is making such voluntary surrender, he shall notify the same to other interested persons. We've already seen who are interested persons in our previous webinar sessions. Those interested parties may within 3 months from the date of such publication may, by an application to the controller, state their opposition in again the same Form 14 in duplicate. Upon satisfaction of the representation made by these persons interested, the controller may, after hearing both the parties, the patentee as well as the opponent, he may allow the surrender of patent and thus by order revoke the patent. One interesting case law on this subject. Milan Laboratories Limited, applicant, and the respondents are ICOS Corporation. Here, this subject matter of today's session is well discussed in a detailed manner, with also taking a cue from the UK Patents Office and the UK Court, where such surrender and revocation have been dealt with in a detailed fashion. The facts of this particular case are as under. An application was filed by this Milan Lab Limited for revocation of the impugned patent under specific grounds to remove the same from the register and to award cost to the applicant. The specific grounds as provided by the applicant seeking two remedies. One, to remove this particular patent from the register and to award cost to the applicant are none other than those specific grounds as enlisted in your Section 64, the grounds for revocation. Some of the specific grounds as specified by the applicant's learned counsel, where this particular patent itself is not an invention as defined under Section 2J of the Patents Act, point number 1. Point number 2, it is not obvious and it does not involve an inventive step. Point number 3, the complete specification is not fairly provided and the method of such particular invention, the grounds of the work leading to that invention is not understandable for a person with average skill and knowledge, and thus the scope of the claim of the complete specification is not clear and the methodology of this particular CS complete specification is not fairly arrived at. Point number 5, the specific ground made is it does not involve a patent leading to grant of patent. Finally, all those grounds as provided under section 8, where if you refer section 8, the grounds where such an application is made, and this application also is made in a foreign territory. So all those complete list of information as required to be furnished under section 8 are not provided, and these facts are not substantiated, and thus the specific ground gave the learned counsel to make a plea that this particular patent be removed from the register and to avoid cost to this applicant. But the respondent, on the other hand, had already submitted application for surrender of patent to both the authorities. One, your Patent Appellate Board, IPAB registry, and two, to the Controller of Patents. On the same day, he has furnished to both the authorities, that is on 9 Feb 2016. And while submitting this particular surrender application, the reasons lodged by this particular respondent, that is ICOS Corporation, was they do not have any business interest in maintaining the patent due to the presence of many such generic products on the market in India, and thus they are not intending to maintain this particular patent, was yet another submission made as the reason for surrender of patent. Thus, the case was filed in IPAB to know whether the revocation application filed earlier will prevail over the surrender application. Thus, the revocation application is the plea maintained by the applicant, whereas the surrender application is the submission made by the respondent, in the instant case being ICOS Corporation. It was also referred that in the month of June, the company already made an application, that is, the respondent had already submitted an this particular Lilly ICOS LLC had assigned this particular patent to ICOS Corporation, and thus the application have effect to the change in name to this ICOS Corporation. The learned counsel, after hearing this particular applicant, they referred two similar cases, one from UK Patents Court in 1999, FSR 284 reference, where it was the judgment in Connaught Corporation, and the other case was UK Patents Office in Welworthy Patent, where the revocation application was filed by Carl Smith GmbH. In UK Patents Court, it is quite similar to this particular case, where it was well clearly observed that the order of revocation stands to have effect until the surrender of patent is accepted by the controller. And in the absence of any argument by the counterparty, on the basis of the evidence substantiated by the applicant, the patent is construed to be invalid. Which means, when there is this pleading made by an applicant, there shall be counter statement lodged by the respondent. In the absence of such counter statement, in UK Patents Court, it was well clearly established that the patent could be revoked. In UK Patents Office also likewise, the patentees did not file a counter statement. Thus, the acceptance of surrender of patent by controller does not result in automatic termination of revocation proceedings, and thus this leaves room for the scope of opening this particular application for accepting revocation as well. And surrender application is not going to stop this particular revocation. Revocation, when it is purely on the grounds, specific grounds as enlisted in the Patents Act, could be the lack of novelty, obviousness, insufficiency, is as referred to in UK Patents Office Court, like how in Indian Court of Justice they have referred the grounds, specific grounds of revocation under section 64 of Patents Act. Thus, the judgment was very clearly passed by IPAB on 11th March 2016 that taking into consideration the representation made by the learned counsel of both the applicant and the respondent, the controller of patent had directed to revoke the patent standing in the name of ICOS Corporation, taking into consideration the change of name application submitted during the year 2015 June within 6 weeks from the date of receipt of order. Thus, the surrender application pending before the controller became infructuous. Why? Because the revocation clearly tallies with the specific grounds as enlisted in section 64, and thus the surrender application is warranted to be unnecessary. Point number 1. Point number 2, no costs were ordered, though the applicant had specifically requested for removal from the register and also ordered for cost. Removal of from the register was made valid and binding because of revocation of this particular application. Now we will move on to section 64, revocation of patents. Specific grounds under which the patent could be revoked, we already discussed as enlisted in section 64. It could be the invention in any claim of this complete specification was claimed in a valid claim of earlier priority date, while we have already discussed in detail about what is priority claim. In another complete specification of a patent which was granted in India. And this particular patent is not an invention, it is not obvious, or it does not involve a patentee step, inventive step, or a patentable product under the Act, or the applicant had contravened the provisions of section 35, which leads to secrecy directions, or under section 39, or the applicant had not disclosed the information as required to be furnished under section 8, where we already observed that when such similar patent is furnished in a foreign territory, what are the information which ought to be disclosed by the applicant in India when they fail to disclose, or if the applicant had furnished false information to the controller, or the invention which was so far claimed was secretly used in India, not useful, or the complete specification does not disclose the source or geographical origin. The patent was obtained by way of a false representation or a false suggestion which was made, or it also led to amending this complete specification which was obtained by way of fraud. And also another ground is this complete specification is not new or not clearly defined or does not involve an inventive step as it is already publicly known before the priority date. While two of these points have a cross reference. The invention so far claimed was secretly used in India. There again, this particular point, they say that if it was secretly used in India, there is an exception when it was for a reasonable trial or experiment, or it was used for the purpose of government or any other person who is authorized by the government, by any other person without the consent or acquiescence of the applicant or the person from whom he derives a title. So in those cases, it will be revoked. Exception on the grounds as specified hereunder. And also another ground of this revocation also has additional rule mentioned in the subsection of section 64, where the invention is not new or does not involve an inventive step or is publicly known. No account shall be taken for this purpose for personal document or secret trial or the secret use, and where patent is made for a product which is made abroad. There is yet another provision which talks about patent could be revoked on account of public interest when it is mischievous to the state or it is prejudicial to the interest of public. Section 65 deals with atomic energy, revocation of patent. After the grant of patent, if central government is satisfied that the patent relates to atomic energy and for which the patent cannot be granted under section 20 of Atomic Energy Act, then it gives the authority to the controller to revoke the patent. Either to revoke the patent or instructing the patentee to make such amendment or modification as this controller deems fit instead of directly revoking the patent. Again, on the subject of section 64 and revocation of patent, we have another interesting case law. Plaintiff or the petitioner in this case was Dhanpat Seth and others, and the defendant or respondent was Neel Kamal Plastic Grades Limited. Plaintiff applied for grant of patent during the year 2002 for a device of manually handling the agricultural produce. Said patent was granted on 11 July 2005. According to plaintiff, the defendant Neel Kamal had infringed producing similar device and supplied the same to Department of Horticulture and the government of Himachal Pradesh and also to couple of private parties during the year 2005. Thus, plaintiff made a plea that the grant of patent was already done during the 2005 to the plaintiff. However, the defendant was using this particular patent as granted to the plaintiff, and thus there was infringement, and filed a petition for grant of temporary injunction to stop the defendant from manufacturing similar device, because this device, the plaintiff claimed that it was an invented device by the plaintiff, and they also sued for damages. The defendant filed an application for revocation of patent. Friends, please remember, this is where section 64 assumes significance. When the plaintiff is going to ask for infringement of patent and suing for damages, defendant has a defense for taking the specific grounds for revocation of patent, provided it falls within section 64. The various objections raised by the defendant in the written statement were: this device is an imitation of traditional product which was very well publicly known and which was used time immemorial prior to the grant of patent, more importantly during the year 2005 to the plaintiff, known as kilta, which was made of bamboo, whereas the plaintiff's product was made of synthetic polymeric material. Section 2J, they have referred, stating that it should either be a new product or process. The case in hand, the defendant claimed that it is of a product. But as per the inventive step, it does not lead to a new product, because already the Skilta product was there in time, since time immemorial, and only the material, the process, there was a shift and it was not a new product. The very name of the product is deceptive, in as much it is not a device for manual hauling, they said. They also contended, stating that here, that particular man has to be in a standing posture and he has to collect the fruits or the other agricultural produce by way of a collecting material from that particular collecting source, where it is a long basket for collection of fruits and agricultural produce. But the defendant had claimed that the design of this product also is a kilta, and they had started adopting it from the year 2001, much before this grant of patent in the year 2005. And they started producing the same and introduced in the market. Defendant had submitted its drawings to Aries Molding Company much earlier to the grant of patent in 2005, that is during December 2001. Thus, the defendant alleged that it had manufactured and marketed the product much before the filing of application for patenting the product by the plaintiff by submitting necessary evidence and proof. Now comes the plaintiff's learned counsel, who submitted that the defendant had infringed the patent by submitting or producing a similar device and supplying the same. Thus, they sued the defendant for damages and also requested for imposing a temporary injunction to not further manufacture or produce this particular product. And learned counsel submitted the patent was granted by these authorities, while the defendant contended that it does not involve inventive step under section 2G. Learned counsel argued by saying that only after a rigorous inquiry and submission of documents and processes, the plaintiff was granted this inventive step. It was well recognized that only the grant of patent happens after completing all these inquiries and investigations, and thus the patented device as a corollary is a new product was the contention. Further, they argued that just because there was a grant of patent, they had an exclusive right to prevent the third parties who do not have consent from using or making the product, the patented product, and also they have this particular right for seizure, production and distribution of the product until the patent is revoked. Thus, they said that till the patent is revoked, all those rights are entitled to them just because of the fact that the patent is granted during the year 2005. Thus, as per the Patents Act, the patentee is entitled to injunction and the patent had not been revoked till date, and thus they had the meritorious claim of granting an injunction. The Learned Counsel also made a submission that once a patent is registered, the patentee complaining of infringement by filing a suit for permanent prohibitory injunction should normally be granted a temporary injunction. They also referred judicial precedents on the subject where this particular patent after thorough inquiry only is granted as patent recognized under the Act. On submission of the relevant documents by both the parties and after hearing the necessary representation from the Learned Counsel, the following decision was made by Himachal Pradesh High Court on 3rd August 2006. As per section 13(4) of the Act, even after the grant of patent, there is no warranty about the validity. Just because the patent is granted, it is not an assurance that it is long binding and sustainable. Claim to an invention can be challenged anytime on various specific grounds as enshrined in section 64 was well recognized by the Learned Counsel of this High Court. Based on the discussion, it was held that plaintiff had no prima facie case. Why? Because this defendant had already submitted an application for revocation and the specific grounds were also represented by the defendant in submission of this ground of rejection or ground of reasons for revocation. Thus, there is no merit on the case as submitted by the plaintiff, and the question of grant of injunction or cost did not arise, was held by the Learned Counsel. Thus, the petition for this grant of injunction stood dismissed in the instant case. Friends, with this we are concluding today's session. Take care, stay safe, stay positive.